James Finn v. Commonwealth.
Good morning, may it please the court. Lisa Kaur for James Finn. Today, Your Honors, marks the 391st day of detention under an unlawful order issued by the Superior Court pursuant to 7658A, in which the Superior Court reviewed this court's decision in Diggs and concluded that the broad reading of that case permitted the Commonwealth to file a motion under 58A, even though Mr. Finn had been released from detention and released on conditions in the district court when he appeared pursuant to a summons for his arraignment in the Superior Court. This court has repeatedly declined in the context of Section 58A to follow the Commonwealth's invitation to rewrite the statute where an interpretation would either render words superfluous or abandon the original intent of the legislature. And I point to AIM, where the court said, invalidating the original amendments, rejecting the Commonwealth's invitation to engage in a massive rewrite of the statute. And in Dayton, where the court recently rejected the Commonwealth's invitation to surgically remove portions of the phrases that appeared in the first subsection of the statute. And recently in Sion, and just this year, Justice Lowy said that even when the result might be counterintuitive, the result may call for legislative intervention and for further consideration by the legislature. And the court may conclude, and the Commonwealth argues that requiring a second arrest for the defendant rather than allowing the Commonwealth to move forward for detention on a summons arraignment might be counterintuitive or could be impractical. But I would suggest that it's counterintuitive when viewed from the perspective of the defendant, of the accused, someone who's been through the district court procedure, had a full hearing in the district court where a judge determined that he could be released on conditions, and then engages in through consultation with his attorney, a selection of a summons arraignment date, appears for a summons arraignment in the Superior Court. It's counterintuitive from his perspective that he would be then subject to detention.
Is there a concern at all that you have a very serious case in the district court being arraigned, and it's within the exclusive jurisdiction of the Superior Court? So it's just arraigned in the district court, but it has to be presented to the grand jury. And the judge is trying to decide, it's a really serious case, but I think there might be some conditions of release that will reasonably assure the safety of the community, and I'm leaning toward that, but if I decide that means in the Superior Court when he appears, if there's a different view, they can't come to a different conclusion.
I don't think that's necessarily the result. I don't think, and I'm not arguing that the court, Murchison entitles the defendant to a second hearing upon his or her arraignment in the Superior Court. And it's phrased in terms of the benefit to the defendant, because there the defendant argued that it would be unfair to permit his continued detention under the district court order, the Superior Court order, in the Superior Court without further review. It doesn't, and it speaks specifically about the benefit, sort of the corollary benefit to the Commonwealth there is that they get a new period of detention. There's nothing that I'm arguing that precludes the Superior Court from engaging in a de novo review when the person appears for arraignment in the Superior Court. But the words that appear in the statute, held under arrest, I submit to the court, must have some meaning. In Diggs, this court could have said that phrase that appears at the beginning of subsection 4 didn't mean anything, that the legislature couldn't have meant to put that there, or that it conflicts with the other provisions of the statute, and so we don't require it to mean anything. The court could have read it out, and the Commonwealth in Diggs argued that there were some circumstances where a summons arraignment would suffice, and then the Commonwealth here picks up that argument. But in viewing the oral arguments for that case, I think there were members of the court that expressed concern about about that position. The only thing, I think, not a narrow reading, but a reading that makes sense, and what Diggs does is, it doesn't broaden expansively as the judge in the Superior Court said. The judge justified his decision, he said, based on a broad reading of 58A that this court took in Diggs. And I would agree that Diggs stepped past the literal construction of the words, and this court said that it's not going to take a strict interpretation of what held under arrest means. But the court did not abandon entirely those words. It said that the words appeared in Governor Wells' letter to the legislature in 1994, that those words, and in the proposed statute, that I think what the language was in Diggs was that the court, that the legislature adopted nearly verbatim. So the court in Diggs, just a few years ago, understood that those words had to have some meaning, held under arrest, and the way to give those words meaning, the way the Commonwealth can give those words meaning when they choose to indict a defendant and when they choose to say this defendant is so dangerous that he or she cannot be released until the trial is had, is to seek an arrest warrant. And that would be a simple way for the Commonwealth to satisfy the statute's terms.
So this defendant, he was arrested?
He was arrested, Your Honor, so he was arrested.
And then released?
He was arrested and then released.
And
sorry.
so why is that inconsistent with Diggs?
That's not inconsistent.
Okay.
So it's not inconsistent, well, it is inconsistent with Diggs for the purposes of saying that you can then move forward on a separate hearing in the Superior Court on a separate process. So the process that brought Mr. Finn to court in the Superior Court was indictment. And there were additional bills, there were additional charges beyond what was charged in the district court. In Diggs, and I would say, so the Commonwealth analogizes Mr. Finn's position to Mr. Soto. And Mr. Soto was the defendant who had been arrested and bailed from the jail on $1,000 cash bail and then appeared. And the court in Diggs found that there was no, that passage of time didn't do anything to sort of invalidate the arrest, and so that he was still held under arrest for the purposes of subsection 4 so that the court or the Commonwealth could proceed at the district court arraignment.
We want a rule that says that if the Commonwealth wants to do this in the future, they should get an arrest warrant as opposed to negotiate a summons so that they arrest your client in the middle of the night.
Well, Your Honor, the problem is that otherwise what you have to do is either read into, say that the term held under arrest means a series of qualifications, or that it doesn't mean anything.
Right.
So in Diggs,
If we follow the Diggs formulation of what it means, right?
well,
Your position is that unless there's a second arrest preceding the Superior Court arraignment, they don't get to move.
so Your Honor, in my reply brief, I posed some hypotheticals that would suggest, so I would think maybe the scenario that would present, I guess, raise the fewest flags for the court would be where a defendant was arraigned and charged and detained in the district court, okay, and held under 58A conditions, and the Commonwealth promptly moved for indictment and arraignment in the Superior Court while he was still in custody. And I think in those circumstances, you might be able to make the argument that custody sort of continued the custodial status of the arrest and also gave evidence or sort of supported the Commonwealth's argument in the Superior Court that person was dangerous and needed to be incapacitated and detained as the sort of case law describes.
Because obviously the defendant here made, well, either you or someone else did a good job and got his conditions of release in the district court, and then when they tried to detain him as a danger in the Superior Court, you have a good ground to say, listen, he's been out for 3 months,
Right.
and he's been able to do this and with the bracelet and
Right.
all that good stuff, right?
And the Superior Court judge saw it differently than the district court judge did. Okay. But what I would suggest is, sort of going back to the examples, and sort of the least problematic being the person who stayed in custody the whole time. But you could have someone, and Mr. Finn is not that person, but if you're taking this case, it's a case that's important to other litigants. You could have someone where he's arrested, and then the case is dismissed or no process, and then there's subsequently a Superior Court indictment. There's no way for this, I think, for this court, without engaging in the kind of judicial bill writing that's not permitted, to put conditions on what it means to be held under arrest when you appear in the Superior Court. I think in a very limited sense, it might make sense if the person remained in physical custody, because you could say that's a continuation of the arrest. But in Mr. Finn's case, he was not in custody, he was on conditional release.
The problem is Diggs, right? Because that kind of got rid of that argument. Because I could see before Diggs, you could have a literal reading of under arrest, and once they make bail and they walk in on their own.
But I think the issue in Diggs that the court was concerned with is that it was the first opportunity for the government at arraignment in the district court to move for detention on their, when the person appeared. And when Mr. Soto appeared, and he had been bailed, the Commonwealth moved for detention. The concern was in allowing a bail clerk who shows up at the jail and collects, $40 for the night's work, to make a determination that would usurp the executive's authority here. Here, the executive branch still had the authority to get a warrant for Mr. Finn. It may not be an ideal rule, but it is a rule that would comply and not render entirely meaningless the words that are in the statute. Because the court had the opportunity in Diggs to say that, and the Commonwealth made the argument, under Section 1, subsection 1, it's enough to be charged. And the court disagreed and said it means arrested or subject to arrest, or for someone for either who has been arrested or for whom an arrest warrant has issued. And I agree, Mr. Finn, on December 3rd, got arrested. By March 7th, he was no longer under arrest. If you say that arrest...
Was that a release date, or is that just a date that other things happened and we already found, oh, he's out already?
I'm sorry.
Was he released on March 7th?
No, so he was arraigned on March 7th in the Superior Court. He had been released, I think it was, the order from the district court for conditional release was January 11th, 2018, I believe. And then that was delayed until the 22nd for administrative reasons. But he was out basically from January 22nd, then he was indicted in the Superior Court on February 5th, and then the arraignment date was selected and he was arraigned on March 7th. I think the real problem in trying to say, well, we've answered it in Diggs and Mr. Finn qualifies as held under arrest, is that you could have substantial intervening events, which include the dismissal of the district court case. And in those circumstances, I don't think you can say that the arrest is not dissipated, which is what the Commonwealth's argument is.
But that's a different circumstance, because Mr. Finn was still under the authority of the court pursuant to the conditions of bail release. In the example you give, if there's a dismissal, he's not under the authority. He's not on bail. He's just on the street.
I agree it's a different circumstance, Your Honor, but I think that you start to then, I guess the condition would be if the defendant remains either in custody or under a conditional release. I don't know, there's no temporal limit on it. I think I would argue that at some point, time does matter. If a defendant's on the street for 6 months, maybe that does go, as Justice Gaziano said, to the issue of dangerousness and the appropriateness of conditions. But I would suggest that arrest can't linger for so long as to make someone months later who shows up in the Superior Court subject to that arrest.
But going back to Justice Gaziano's point, I mean, the problem is you've got a guy who says, I was released by a judge after a hearing. I complied with all my conditions, and under your rule, you'd have, the DA would have to seek an arrest warrant if they even contemplated the possibility of a 58A. So the safer course of action for the DA would be get an arrest warrant in order to preserve their chance of moving for 58A. And then you'd have people who, after a judge considered the issue of release, decided they could be released on conditions, now are being brought in for a night or a weekend
But,
because of our interpretation of 58A.
but Your Honor, so the practical reality is that when the Commonwealth moves, so in that scenario, the Commonwealth on a summons arraignment would move for detention. That individual could be taken into custody, so there would still be the custodial effect. And just as the rules permit under 58A, a continuance could be given to the Commonwealth for good cause. So there could still be that detention that would happen with the arrest. The arrest could be affected at the same time as the...
Yeah, I understand, but if you're right, the next defense counsel who has it's going to say, Your Honor, in the Superior Court, my guy was placed on bail release. He did everything that the judge in the district court asked him to do. He was fully in compliance, and now the DA, just because it wants to seek a dangerousness hearing, now is arresting him again, and he would have showed up voluntarily, could have been summoned in, he could have continued the compliance with the judge's conditions, but now he's been arrested because you say we have to do that in order to get a 58A hearing. I don't know why that makes good sense. I don't know why the legislature would have wanted that to be the case.
Well, I would argue, Your Honor, that the court has found numerous times that the legislature has not artfully crafted Section 58A, and there have been opportunities for revision and indeed for striking out entire clauses of the statute. And I'm sure that the court is aware that the governor has proposed a really sweeping rewrite of the statute that was before the legislature in 2018 and is back before the Judiciary Committee now. But what that, although the court says that it may not make good sense, what that request is consistent with, Your Honor, is the Commonwealth's position that this person is dangerous and cannot be released and should be detained until a trial. In this case, what took place was entirely inconsistent with sort of a good faith argument that that person needed to be incarcerated until they were tried.
And of course, trial counsel could have argued that, Your Honor, if they thought he was so darn dangerous, they should have did an arrest warrant. They didn't choose to do an arrest warrant. He's complied with his bail conditions below. Why would you interfere with what has been a successful release by the district court judge? But you lose the opportunity to argue that if you win, because they'll have to arrest him.
I don't think that you couldn't make the same argument just because the Commonwealth has to comply with, procedurally comply with getting an arrest warrant in order to give the words in the statute meaning. Doesn't mean that the defendant couldn't still argue that, because somebody that comes in, because that's just another factor that the defendant could raise, his good behavior on those conditions of arrest during the months before indictment, could still raise that as to the issue of either dangerousness or conditions of release. But my argument is that fundamentally that held under arrest can't mean that this arrest from any point prior in time persists. There has to be some limit on it. And in order to set reasonable limits on it that give, I guess, defendants knowledge of what is required and the Commonwealth's knowledge of what's required, to give effect to what the Commonwealth is arguing would require so many qualifications that this court would really be engaging in the kind of legislative rewriting.
Are you seeking to, so once a defendant is released, as your client was in the district court?
Yes.
And you recognize, of course, it could be, happen again in the Superior Court, but are you saying that the Commonwealth, absent this procedure of arrest, kind of arrest in the courthouse, the Commonwealth would lose the ability to move for detention? Because they're no longer under arrest?
Yeah, I think that has to be the consequence. I mean, unfortunately,
So the district court judge made that decision. The person is now on conditions, and logically, your position would be once that happens, it's over.
Well, yes, and I understand that it may be, I think as Justice Lowy said, you may have counterintuitive results. You may think that the legislature couldn't have meant for this to happen, but to rule the other way, again, requires qualifications that go beyond.
I don't know if whether Diggs reaches it though, but there is a concern. Any time that somebody is arrested on a warrant, there's concern for the safety issues for the police officers and for the person being arrested.
Yes.
And also, it's just a little concerning to have the district court judge make a decision that somebody should be released and then have the executive branch nonetheless go seek an arrest warrant for the person, where there hasn't been any violation of conditions of release. So if we were to adopt your, we'd have to say that the legislature, in putting those words in, meant that the held under arrest didn't reach this circumstance.
I would suggest that when the legislature enacted Section 58A, it wasn't a statute that was easily applied in the district court and in the Superior Court, even though in the statute it refers to both the judge of the Superior Court and of the district court. So it suggests that, and that's why Murchison says that this hearing can be held in the Superior Court. But there aren't, in the statute, there aren't provisions that allow for the sort of the bind over transition of conditions of release or of detention. I hear Your Honor's concern about the issue of arrest, but fundamentally, if you're going to be seeking detention of an individual under 58A who is at liberty, they're going to be taken into custody. That arrest is going to be affected, whether by an officer executing the arrest warrant or in the Superior Court by a court officer taking that person into custody. And maybe that's a more controlled environment. But from the perspective of the defendant, there's still that loss. That loss of liberty occurs, whether it's in the Superior Court for the purposes of taking the person into detention to hold the hearing, and then for the prolonged period of detention, or for the arrest so that the hearing may go forward at all.
Now, do we have to first conclude that this case, that the charge indecent assault and battery is a predicate offense before we reach your other issue?
Well, the issue, do you mean decide Vieira first, or? I think if you decide Vieira and decide that it's not a predicate offense, that was not an issue that I raised, and I think it reflects the way sometimes these issues come before the court in a piecemeal way, because fundamentally my reaction was, this gentleman's not held under arrest, and that was the argument made that the Commonwealth doesn't have the authority to move, not even that there was not a qualifying offense. And I cited that I mentioned that in my reply brief because the Commonwealth argued that it was an offense under the force clause, and I wouldn't necessarily concede that. I think if you decide Vieira in the defendant's favor, then very likely that would apply to Mr. Finn, and his issue of custody would be resolved. It's not, but I do think that there's benefit to deciding this issue of what it means to be held under arrest when someone shows up in the Superior Court. And I would just ask the court to take, again, into consideration that Murchison, although it says that a new hearing is authorized, it views that from the entitlement of the defendant and from, I think, a spirit of protecting the defendant's rights. And I'd go back, I didn't mention, but the rule of lenity that the court discusses in Dayton very recently supports the conclusion that ambiguity should resolve in favor of the defendant. And Diggs, this court interpreted that phrase reasonably, not broadly or expansively as the Superior Court judge argued, but reasonably, to give the words the meaning, reasonable meaning. And I don't think, even though it may seem reasonable, that an arrest an initial arrest could provide the basis for the Superior Court. There are so many circumstances that could intervene and time that could pass that it's really, I think it's an impossible job for this court to put the conditions on that to give it effect so that someone like Mr. Finn could still be considered to be under arrest in the Superior Court.
All right, thank
If
you.
there are no further questions, I would rest on my briefs. Thank you.
Ms. Sullivan?
Good morning, Catherine Sullivan for the Commonwealth. With me is ADA Christina Ronan, who handled the Superior Court proceedings. To be clear, the Commonwealth is not asking for a massive rewrite of the statute. I don't think there's any indication of that in our brief. We've provided 3 pathways to interpreting the statute to cover situations such as those exist here. I don't believe Diggs went far enough to account for this situation, though, as I say right up front in my brief, this defendant is covered. He was arrested.
Ask about the holding in Diggs. So Diggs, I'm just reading from Diggs. We conclude that where a criminal defendant has been arrested or is subject to an outstanding arrest warrant for a enumerated offense, the defendant may be subject to pretrial detention under 58A4, even if the defendant is not held in custody following the arrest. And here's the key: so long as the dangerousness hearing takes place immediately upon the person's first appearance before the court. Do we need to modify our holding now? Because that holding, because we've got the first appearance, he's let go, right, on conditions, and now we're basically putting him back in a second appearance, right? So we're going to need to fix our opinion itself, right?
Correct. Not only that, but this case presents the wrinkle where there were 2 new charges, right? So even though you had the same victims, I mean, so for those 2 new indictments, there was only 1 indecent A and B charged in the district court, and then in the Superior Court, there were 3 indictments for assault and battery on 2 additional children that had been named as victims on the obscenity charges. So it is his first appearance on those 2, right? So, and this is the problem with this type of issue, is that there are always going to be exceptions to a rule.
Well, it would be the first appearance even if there were no new charges, correct?
In Superior Court, for sure.
Superior Court.
Yeah, absolutely.
So this is the first appearance in Superior Court.
Absolutely.
And it's the indictment now results in the district court complaint being dismissed. So this, I think all agree, we treat this as a new case.
Right, and that's why Murchison is so compelling, because it presents the real possibility where those charges just cease to exist. And here you have a defendant who is twice found dangerous. There's no possibility of him not being dangerous. Just because he's out on conditions doesn't mean he's not dangerous. So in addition to the issues having to do with arrest and the Superior Court discretion, we have those procedural complications.
But going to your sister's point, would we be in a different circumstance if you had dismissed the case against him and then 2 months later indicted him?
No, because it was his first appearance then in Superior Court.
But would you have to arrest him if you were to have dismissed the cases on June 1st and then on September 1 indicted him, would you not need to have arrested him on the indictment since he was not on bail release?
Theoretically, if we're going to apply Diggs, then yes. The problem with that is the requirements for the arrest warrant and the general policy of our office, and it may be other ADA's office, to issue a summons. And that is directly in line with the statute and the rules, Rule 6 of the Criminal Rules of Appellate Procedure. And this is something that, I've sort of thought about over the past week or so. It's not in my brief. It talks, in the reporter's notes, it talks about the fact that a summons is much preferred to a warrant. And in fact, when an ADA applies to get a warrant, not only do we have the safety concerns that Justice Lowy raised, but an ADA has to attest to the fact that a defendant is a flight risk.
But given the hypothetical that the chief just gave you, how do you get around the words of the statute?
I'm not sure we could, right? If we're limited to the construction in Diggs. I like my interpretation of the statute's subsections and how they all can come together and be interpreted. And I don't believe that the legislature necessarily meant that every single defendant had to be held under arrest to be subjected to a dangerousness hearing.
And is this a problem, this isn't going to be a problem in the new legislation, assuming it passes, I assume?
In the new legislation, Governor Baker's proposed that a dangerousness hearing could be held anytime.
Okay.
And he uses the language charged with certain crimes, correct?
Right, and I think.
Charged with crime rather than arrest.
Right, and I'm not trying to completely get out from under the requirements, some of the strict requirements of the statute. As I say in my brief, Section 1, subsection 1 has some pretty specific demarcations and distinctions where I think under the forced clause, someone just has to be charged. Where if it's a charge under the abuse clause, they have to be charged and arrested. So I'm not trying to get out from the statute's requirements.
And what do you say about the Vieira case, or whether we have to address whether this is a predicate offense first?
So I think that,
Buying offense.
right, so as is obvious from this case, this is an issue that has the potential to rear its head going forward, So it's worthy of deciding, and certainly the defendant will get the benefit of Vieira, where his case is pending, will be pending, will be on appeal, so he'll get the benefit of any decision. So I don't think this court has to decide that issue in order to address this issue. The defendant didn't raise it here. I don't think it was properly argued in the reply brief. The rules prohibit that. The new rules, 16C, precludes that. So, I agree with my sister in that where this issue is capable of being raised again, we should decide it. And I think I've presented the court with several paths it can take to either explain Diggs or the statute or the wording. And if this court would like us to issue arrest warrants, we will. And that's the sad reality of that is I don't think we need to.
Is it also not just a sad reality, but it couldn't have been the reality at the time that the legislature passed?
Of course, and I don't think they considered that, or intended that, frankly. My brief fairly lays out the substance of my arguments. I would like to mention that the 10-month delay in the defendant's detention, without minimizing it, it took 10 months for the defendant to present his application to this court. That could have been done many, many months ago and resulted in his continued detention without a discussion of this issue for certain. So if there are no further questions, I'll rest on my brief. Thank you.